Welcome to part two. I'm Adam Liptak. I cover the Supreme Court for the New York Times. I'm here with a murderer's row of Supreme Court experts and a target-rich environment in the current court. So we are going to have a very interesting discussion. I'm going to try to stay out of the way and let these experts tell you what's going on. With me, they need no introduction, and we'll get only brief ones from me. Kannon Shanmugam of the Weiss firm, Carter Phillips of the Sidley Austin firm, Pamela Karlan of Stanford, David Strauss of the University of Chicago. Between them, I did the math, they've done 9,000 Supreme Court arguments. Carter has, you can say in private practice, whatever the criterion is, the answer is Carter Phillips. So just this week, we had yet another shadow docket, emergency application, unreasoned order affirming a major Trump administration immigration initiative, second one of the summer. We had Joan Biskupic's very interesting reporting about switched votes, not only in the census case, which was seemingly apparent on the face of the decision, but also in the Gundy case, which remains inexplicable. And so I'm hoping we'll get into some of those things, but let's start at a broader level of generality. We have now in John Roberts, for the first time since 1937, a Chief Justice who is also the median justice, who also sits at the court's ideological center. And I wonder, I'm just going to go from Kannon and across the board. What have we learned about John Roberts in this term? Are there surprises? Is his newfound power being used wisely? What do you think, Kannon?
Well, thank you, Adam. I guess I'm the first one who gets to swing at that fastball. It's great to be at William & Mary, as always. I think, I'm going to weasel out of it. I'm going to duck out of that fastball a little bit and say that I think it's a little bit too early to know how his role has changed. I mean, in part because the court had, an uncharacteristically low-key term last year and didn't have a lot of cases in hot-button areas where the Chief's vote might have been the vital vote. Indeed, you really did not see the sort of stereotypical 5-4 breakdown on the court that we've kind of come to know and love in recent years. And if anything, I think the interesting fact from last term was that the justice who was in the majority the most often was not the Chief Justice, but in fact Justice Kavanaugh, and that is often one measure of where the center of the court actually lies. And last year, Justice Kavanaugh seemed to be there in a lot of areas. He voted most frequently with the Chief Justice, and I think that there are some ways in which the two of them are very similar. And so I think this term is going to give us a lot more data with regard to the Chief, because the court has a number of cases in hot-button areas that I'm sure we're going to be talking about over the next 24 hours already on the docket, and a number of other cases that are sort of in the pipeline that could be added to the docket. And so we've come to expect blockbuster Supreme Court terms in recent years, and I think this year will represent a reversion to that norm.
Carter, would you also like to do a too soon to tell version of the answer, or?
Well, I mean, it's obviously too soon to tell because you didn't even have a full term with all 9 of them on the court at the same time. And to me, at least, it'll be at least as interesting as these things play out to see to what extent, what is the basis on which someone on the liberal side seems to be able to coax at least one other person from across the aisle to join along with them in a variety of different contexts. So that was a pretty remarkable trend last term. Whether that can continue for the foreseeable future or maybe even be increased some is in some ways an equally interesting development. As a guy who clerked for a Chief Justice who was not in the middle of the court and still gets called the burger court regardless of that, I'm not sure, frankly, how important it is to have the Chief Justice be the pivot, and it's just as plausible that Justice Kavanaugh will in fact be the pivot. It's just the distance between them may not be all of that significant, but there'll be a certain number of cases in which it may make some difference. My guess is you'll have two in play in a way that, where I used to always say, so it's 4-4, wherever Kennedy comes out is where it's going to come out. It's sort of 4-3, and I don't know where the Kennedy and where Roberts and Kavanaugh will come out, and we'll have to figure that out as usually after oral argument.
Pam, does that sound right to you, that we have a new soft middle of the court made up of Kavanaugh and Roberts?
Well, I think it depends on the issue. The thing that I want to point to that I think is important about the Chief Justice is he's very much a kind of institutionalist, and he's concerned with maintaining the court's position and the court's kind of political capital in the American ecosystem in a time of immense polarization in the other branches of government. And so I think one of the things that was telling this past year is they tried to avoid taking cases that made them look as if they were in the midst of partisanship, and the two where they were really forced, in essence, to take them, which were the redistricting cases where they're forced by the jurisdictional statute to take those cases, and then the census case. I think the Chief's, a lot of what the Chief said in his opinion in the Rucho case is designed to say we are not a partisan institution. And so I think a lot of what he's going to try and do is make the court seem as nonpartisan or apolitical as he can. And he has a bully pulpit in which to do that because he has the signing power. And obviously he has some sway over what the court takes and doesn't take.
David?
I'm going to agree mostly with Pam, although I'll go a little further, I guess. I think the Chief is pivotal. It's going to be pivotal going forward. I don't have a good sense of Justice Kavanaugh, but it is pretty clear that three of them really want to do some stuff. They want to overrule some precedents and really want to move the court, move the law in a certain direction. They don't seem interested in just kind of going along in a relatively incremental fashion. At least three of them want to do that, and my guess is Justice Kavanaugh is closer to them than he is to the sort of more traditional, let's decide these issues one at a time, let's not go too fast. The Chief Justice clerked for Henry Friendly, and he's still got a lot of Henry Friendly in him, I think. That, the old, sort of old-fashioned, small suit conservative judge. And I think that's going to be the battleground. How fast do they move? How many precedents do they overturn? There are already signs in some of the opinions, obviously Justice Thomas's opinion, also some of Justice Gorsuch's opinion. They're laying the groundwork for overcoming some precedents. And I think the Chief will be the one who decides how fast they move in the future. I agree we haven't seen enough this time to tell for sure, although there are signs. But that's where I would locate the ballpark.
So the last time new justice was in the majority more often than any other justice was David Souter, which might be scary to some. And it does seem, at least in the early going, that Justices Kavanaugh and Gorsuch, who look so similar on paper, they went to the same prep school, they clerked for the same justice in the same term, they were both on the circuits for about a decade, they were both favorites of the Federalist Society, turned out to be a little different on the court, right? And voted together 54% of the time, barely ahead of Kavanaugh and Breyer, and Kavanaugh and Kagan about 46% of the time. What can we say so far, Kannon, about how these two justices differ?
I think that in some ways there are different kinds of conservative justices, and I use that label as a sort of advised shorthand because I do think that methodologically there do appear to be some differences. I would say that Justice Gorsuch is much more of a Scalia-Thomas sort of conservative justice. I think a fairly consistent devotee to the originalist and textualist methods of constitutional and statutory interpretation championed by Justice Scalia. I think that Justice Kavanaugh is somewhat more pragmatic. I think he would describe himself as an originalist and textualist, but I think he is more willing to use a broader array of interpretive tools. And I think in his heart, he is very much more of an institutionalist. And in that regard, he's sort of closer to the Chief Justice. And then you have Justice Alito, who I don't know that I would be as quick to lump together with Justices Gorsuch and Thomas as David was, because I think that Justice Alito is in many ways an old-fashioned Rehnquist-style conservative in many ways, perhaps more of a believer in stare decisis much more of a sort of a law and order conservative, and you see this schism not infrequently now in the court's criminal cases, where you have Justice Gorsuch often crossing over in much the same way that Justice Scalia did to join the Democratic appointees on the court. And so I think what you're seeing, I think the dynamic on the court is similar to the dynamic that we've seen for a number of years, in that the 4 Democratic appointees are increasingly voting more in lockstep, and there are genuine methodological differences among the 5 Republican appointees. And I think that's what causes the dynamic we saw last term, where, as Carter says, you had, perhaps one of those conservative members being picked off or more in particular cases and quote unquote crossing over. Now, whether we will see that if the court has a term with more hot button issues, I think is very much an open question. That was very much the dynamic last term.
What are you seeing, Carter, with the 2 newest justices?
Well, I mean, it is pretty clear to me that Justice Gorsuch is quite comfortable sort of being linked on some pretty fundamental issues with Justice Thomas, and in ways that are probably a little unnerving, at least for those of us who are advocates before the court, because it's tough enough when you think you know where the precedents lie and trying to sort out what you're going to argue, when you're told at the beginning that actually at least a couple of the justices are going to start from square one. It changes your frame of reference, at least to the extent you think one of them might be the 5th and deciding vote. To me, the big issue as an advocate that going forward is going to be this question of how is the court going to deal with stare decisis, and are we going to fight this? I mean, it seems like almost everything is fair game. The cases that the court decided to overrule this term, I mean, Nevada versus Hall. I mean, that's a venerable case because it was the year I clerked. So that shows you exactly how venerable it is. I mean, if he'd sat around and asked me 10 years ago, what are the chances the Supreme Court's going to rear its up and take down Nevada versus Hall? I would have said 0. Who cares? It shows up once every decade. I can't imagine that it's a hotbed. But the court, found it. Somebody raised it directly. They granted certiorari on it and overruled that decision. So to me, I'll be interested to see if Justice Kavanaugh is that sort of cavalier in dealing with a lot of different precedents, even though obviously he went along with that one. But there's a part of me that says I'll be surprised, and that's one of those places where the 2 of them will clearly diverge now and into the future, I think.
I mean, it was interesting, last term, the court took 4 cases where the sole question presented was, should we overrule one of our prior precedents? And you'd think that just in terms of vote counting and thinking, they wouldn't take a lot of cases to say, are we going to overrule these cases? And then say, nah, not so much. And yet they only actually overruled the prior precedent in 2 of the 4 cases. In one, they kind of hollowed it out, and in the other, they reaffirmed it. And so this question of, strategically, if you want to get rid of a precedent that's on the books, do you press right now to overrule it, or do you try to sort of nibble away at it in a bunch of ways over time? Is a strategic question for the justices who want to change where the law now is.
What do you think of the amount of argument that goes into the law of stare decisis? Because it seems to me that if someone is hell-bent to overrule a case, they're going to work the stare decisis factors as they want to. And the precedent on stare decisis is not going to guide them.
So you're talking about like meta stare decisis,
Yes.
the stare decisis of stare decisis.
I think he's talking about result-oriented decision making.
I'm talking about
I'm trying to be highly theoretical.
law professors.
No, I mean, obviously, if you really think the precedent was wrong, the number of times that a justice says, I think this is a terrible, terrible thing, but I'm going to stick with it, is pretty low. That is,
Although Justice Stevens would say that.
Yeah, no,
Frequently, actually.
Yeah, no, there were a lot of cases where Justice Stevens dissented, and then once the court decided the issue, I mean, the biggest one being affirmative action, that he was in the dissent in Bakke on whether you could have affirmative action at all, and yet the court having decided it, he never went back to the issue.
David, what are you seeing with the new justices?
Yeah, I think, and on this question of stare decisis, I agree with Adam that the kind of boilerplate they trot out about the stare decisis factors is kind of useless. I do think that it's possible to make a more or less compelling case about how disruptive it'll be to overrule precedent. I think there's room for argument there. As far as the new justices, I guess I sort of want to half agree, half disagree with Kannon. I mean, I agree that Justice Alito has a different kind of rhetorical pattern than Justice Gorsuch for sure, and maybe Justice Kavanaugh as well. But gee, I don't see him as being a sort of devotee of precedent. I mean, you know, he campaigned to bring about the result that he brought about in Janus. There was no sort of hesitancy about that. And as Pam said, they took some cases with the question was, should we overrule this precedent? They only did it twice, but I think you're going to see more and more. I know of at least anecdotally, at least 2 cases up there now with the question presented is, should the court reconsider this fairly major case, Employment Division against Smith and Hill against Colorado? I just happen to have stumbled across those. And I think, you know, the word is out there that you can ask for some of these cases that have been kind of criticized a lot in conservative legal circles, and you can ask them to be overruled. Now, there is a risk of going too far too fast, but I think that is very much up for grabs in future terms. And I think the chief will be the brake. I don't see Justice Alito being the brake, and I really kind of doubt Justice Kavanaugh will be a brake, although I think he may give the chief some cover sometimes.
Can I say just a couple of things in direct response to that? I mean, the first is that Justice Alito has had a couple of these sort of short, separate opinions, including his opinion in Gundy, that I think are sort of these, you know, slightly snarky opinions that sort of say things like, you know, well, you know, maybe this doctrine is questionable, but this isn't the right case, or, you know, I thought that Chevron was still the law. You know, he's had a few of these opinions that I think reflect at least some sense that stare decisis plays a role. But you're right, there have definitely been cases where he has, you know, himself called into question the court's past precedents. On the issue of how litigants are approaching this, I do think that part of what is actually happening is somewhat more innocuous, which is that the court in a number of cases has sort of said, well, you know, we might overrule this precedent, but no one's asked us to do it. And so, you know, you've got to put that into play. If you're representing a party and, you know, one of your routes to victory is overruling a past Supreme Court precedent, if you don't frame that as an issue in your cert petition, you run that risk in litigation once you get to the merits phase. And I think that that is part of what is going on.
But they induce it, I mean, by writing opinions that say, we don't like this case. But
In an appropriate case, the court might re-examine.
Right, I mean, they're inviting that from the.
Yeah, no, I think there's a certain...
That's true, but that one, and that's easy, that's a layup. I mean, if a client shows up at your doorstep, you know, 2 years ago, it showed up, in fact, the client did show up mine 2 years ago, and said, you know, we lost this case because of our deference, and what do you think we should do with it? And I said, well, you should go tell the court they ought to overrule our. And then the administration changed the rule 2 days later and gave us back the win that gave us the win that we were going to lose. So we lost our hourish. But you know that's easy. That takes no genius to say go ask the court to overrule an opinion that they have. You know, 5 of them have said at one time or another they think it was a ridiculous rule, even if they at the end of the day didn't decide to overrule it when the time came. I still think though for most advocates, something that I didn't do, at least in the first 20-some years that I was practicing law, was think in terms of precedents that you would take a shot at and under what circumstances and how do you play that, because that would have seemed very provocative to come in and say, I think you ought to think about overruling something. Not that they wouldn't. Some of it's driven by when the court tells you that, but I think you have to at least have in mind, are there doctrines that have been criticized, and then what are you going to do about them, and how far are you going to go? I mean, I'm assuming now after the Tennessee wine case that court's not going to come back and deal with dormant commerce clause, but who knows if somebody wants to raise that one again down the road.
David, let me ask you about a distinctive feature of this last term, and indeed of the Trump years at the court. Extraordinary number of unusual applications from the SG. Often stay applications seeking to stay injunctions issued by judges, resistance judges in the Northern District of California, nationwide injunctions. And the court seems very often ready to play. And even though in other settings it will blithely say we're a court of review, not first view, on very thin briefing, and in orders that are vastly consequential but have no reasoning. All kinds of things are happening. Am I right that this is distinctive, and should we be troubled by it?
It's certainly distinctive. The numbers are very dramatic. How often the Solicitor General has sought some form of extraordinary relief, either a stay of district court proceedings or sort of before judgment or vacation of a stay issued by a lower court. The numbers are remarkable at how often that has happened in this administration as compared to previous administrations of both parties. I think it's kind of an interesting question on the side of whether the Solicitor General can be criticized for doing that when the court has not pushed back. The court has not rebuked the Solicitor General. In fact, Justice Sotomayor maybe a little bit in this most recent thing, but really she was directing what she had to say at her colleagues rather than at the SG. Whether the question be whether the SG has an obligation to protect the court from itself. I think that's kind of an interesting question. But be that as it may, this is an unusual feature. I think it's unfortunate. I think it's a consequence of the polarization. I think, as Adam said, these are important rulings. They're important concretely on the ground, but they also commit the court. I mean, the court will get one of these stay applications and issue a stay on no briefing, just a barest briefing, no argument, without full consideration, without the benefit of lower court opinions. And then it's going to be very difficult for them to rethink. Not impossible, but difficult for them to go back and rethink the position they've taken. So they're sort of snapping into positions. And I think what makes it, unfortunately, kind of easy for them to do that is the way they're a little bit on teams. And, this is something from those judges in the lower courts that we know what they're up to. They're trying to thwart the Trump administration. We're not going to allow it. And that, I think, makes it easier for them to reach judgments without thinking it through. I think it's an unfortunate development. I wish the court I wish the court wouldn't do it. I think the doctrinal avenue to stop doing it is to insist that the government actually show concretely why the injury to it is so severe that it needs extraordinary relief now compared to the possible injury to the people on the other side. But the view seems to be, no, if the government is being prevented from implementing a program, that is per se a serious injury, unless the merits are very strongly against it, we're going to grant it its relief. I think that's misanalyzing the question, and I just don't. It's a very peculiar way for the court to decide these questions so quickly with so little briefing when the stakes are so high.
Can I say something about that in response? I mean, David and I both worked with Rexley when he was the Solicitor General, and candidly, I suspect that Rex would not have authorized anywhere near as many requests for extraordinary relief, not because he doubted whether he might actually be able to succeed. Just, his view was that we should save that kind of a request for something where it really means the world to the federal government and not burden the court. But he got criticized a lot for not using the full extent of the goodwill and authority that he had and that office had at the time. And ultimately, he walked away perfectly happy at the end of the day. But I think the point you made, which is really the telling one, is the court, if it wanted to discourage it, there's a pretty easy way. You either say no on occasion or say no with something that expresses at least some agitation with the notion that you're going to keep interfering with the ordinary course in which we operate. Because the truth is, most of us, at least I think, envision that the justices are much happier in a world where you file your cert petition 90 days after and an opposition, and it gets granted and it gets heard and it gets done, and then they get to reflect on it for more or less time depending on the circumstances. And that they wouldn't be that thrilled with this, but if they're not going to say anything, I can understand why the administration would have a hard time saying, well, why would we stop now?
Can I offer a little bit of a defense of both the administration and the court? I think that I agree with David and I agree with Carter that this is something that the court doesn't like. But I think in many ways this is just the problem with nationwide injunctions, because if you have a district court entering a nationwide injunction against an important executive policy initiative, of course there's going to be tremendous pressure on the executive to challenge that, because if they don't, the policy is going to remain enjoined. And the Supreme Court is going to feel some degree of obligation to step in precisely because it's a nationwide injunction, and these nationwide injunctions essentially thwart the ordinary development of the law. And so, I think that this is a dynamic that you could easily see in a different administration. You saw, just the slightest touches of this in the Obama administration when you had the nationwide injunction issued by Judge Hainan in Texas of the earlier version of either DACA or DAPA, whichever program it was. But now we're seeing this sort of in full flower. And I think it's a problem that is potentially here to stay. And I agree that the Supreme Court is sort of at its worst when it is acting on an expedited basis and when it's acting on limited briefing, and this practice of issuing these orders that really have no explanation is, very much a deviation from the court's ordinary course. But it's totally understandable why this is the dynamic now with these nationwide injunctions becoming more common. And the only other thing I would say is that I think even leaving aside nationwide injunctions, you just see in civil litigation more generally, more of the action now is in the area of interlocutory orders of one variety or another, whether it's preliminary injunctions or appeals on class certification, because in civil litigation, the reality is that very few cases go through trials and final judgments. And so to some extent, even in litigation that doesn't involve the government, you're just seeing a lot more pressure being put on appellate courts and even the Supreme Court to decide issues in a kind of preliminary context.
Can I just say something about that? I mean, the nationwide injunction issue is tricky and hard, and it's not clear that it is a difficult issue. But if the court is unhappy with nationwide injunctions, it should grant the case, raising the question whether nationwide injunctions are okay, and say whether they're okay. And if it's unhappy with the way courts of appeals are dealing with interlocutory orders on class certification or other matters, it should tell them that in a full opinion, rather than doing this sort of one at a time. And I agree nationwide injunctions are part of this. I actually think there's a lot more to be said in defense of them than a lot of people do. But okay, if the court doesn't like them or doesn't like them in certain circumstances, think it through, work it out, tell us about it instead of this kind of piecemeal thing that they're doing.
So the other night in this asylum order, there were two noted dissents, Ginsburg and Sotomayor wrote. And the journalistic problem then is everyone thinks it's 7-2, but maybe it's not 7-2 because maybe people in this kind of setting silently dissented, but just didn't say so. Do you guys have intuitions about whether that's likely or not? Whether we can take at face value what the vote count was?
I think it could happen. I don't know enough about the particular context here to know how likely it was.
And I guess we did see in one of those, also, we had the death applications last year where the question was, does a religious inmate get to bring a faith advisor of his choosing into the death chamber with him? And it turns out that Alito had dissented but didn't choose to say so for some time.
I actually have a speculation about this. I think there are three people up there who really are trying to avoid 5-4s along the usual lines. I think the chief wants to avoid them. I think Justice Breyer wants to avoid them. I think Justice Kagan wants to avoid them. And I think there's some stuff going on with that. And it wouldn't shock me if Justice Kagan and Justice Breyer suppressed their dissent in this case in order to kind of help out the chief. This won't be a 5-4 partisan. And actually, this is just wild speculation. In a previous iteration, not a previous iteration, but a previous case that was a little bit like this one is about applying for asylum in the first country you come to. The previous case was about whether someone who had snuck in could be denied the right to apply for asylum. In that case, the court denied a stay, ruled against the administration by a 5-4 vote with the chief siding with the liberals. And it wouldn't, I don't know how explicit this is, but it wouldn't shock me terribly if the idea was, okay, we will not make this a 5-4 in exchange for your having avoided the partisan 5-4 in the other case. But I think you're going to see that dynamic, and I think you're going to see suppressed dissents, as we've already seen kind of opinions that are kind of mushy opinions in order to avoid that kind of 5-4 breakdown.
And interestingly, that earlier asylum case you mentioned was also from Judge Tiger, it prompted the Trump criticism that it was issued by an Obama judge, which prompted the chief's statement that there are no Obama judges and no Clinton judges and no Bush judges, questionable statement. But it was in light of that that the chief's vote also might have made a bit of sense. So the big surprise of the term, I think we could all agree, was the census case. Any sense of what was going on there? It's after argument, a lot of people reported, including me, that it sure looked like the right side of the court was going to rule for the administration. What do you think happened, Pam?
Well, you get 80% of the way through the opinion and you still think they're going to rule in favor of the administration. It's sort of like, watching a ball in a bowling alley and it's going whoosh at the very end.
That's why most people read the last line first.
Yeah. I think part of what happened in that case is that the Chief Justice decided that if the administration is not going to take seriously the responsibility to adhere to the rules, he's not going to save them under conditions where it's, this goes back to your quotation, your allusion to the fact that the chief clerked for Judge Friendly. There's that line in the last part of the opinion, the quotation from Judge Friendly about, as a judge, you can't be like more credulous than the average guy on the street. And the problem here is that by the time, first, the administration just did a disgraceful job of trying to come up with a pretext here. If the administration had just said, we're curious about whether or not people are citizens, they would have won this case going away. They would have gotten the 5 votes. But, it's like, for the administration to claim that the reason they had to ask this question was to enforce the Voting Rights Act was so patently ludicrous and so clearly pretextual that when stuff started coming out about that, it was really hard, I think, politically for the court to ignore that because they would have been lambasted, especially after the Hofeller stuff started coming out, And so it was so obvious that what had happened here was the purported justification was not the real justification, that there's that also that line, I think it's of Justice Frankfurt's, we can't ignore as judges what we know as men. And this was what would have happened if the first travel ban had gone up to the Supreme Court, which is when you lie, you get in trouble. It's the cover-up, not the crime that causes the problem here. And I think that was what was going on with the case.
Other thoughts on the census case?
What's interesting, I mooted the census case at Georgetown and said it after the council were finished that, it at least it felt to me, if you, coming from it fresh, not having a dog in the show, just reading it, that if this had come up in any other context, it wasn't census, it was a more mundane, ordinary administrative law case, it struck me as the kind of case where the DC Circuit routinely says to the agency, seriously, this is the best you got, go do it again. It's just not right. And I thought, why aren't we sort of arguing it in that sense? Why are we being why do we have to raise the rhetoric in it and talk about pretext, et cetera? Just like, this doesn't work. It's not an adequate explanation, and DC Circuit judges have seen these 1,000 times, right? And there are two or three people from the DC Circuit. At least one of them ought to have that same reaction, say, you know what, I've got a deja vu reaction to this. And in some ways, it sort of felt like, even though there may be lots of other motivations for how the chief came out on this, but in some ways, if I were him and I were trying to sleep well at night, if I thought this made much difference, I would say to myself, if I'd been a DC Circuit judge and this had come up in an ordinary context without all of the political hoopla about it, I would have readily set it aside and said, this is a nice try, but this isn't getting it done, do it again. Now, originally, if you do that, the timing runs out and you don't have enough time to actually be able to do it, but that's not an excuse for not to say to the agency, look, this isn't actually good enough for government work, but we don't have enough time for you to be good enough for government work in this case, so we're going to give you an even bigger break. That can't be right.
Yeah, I mean, it's interesting. Obviously, we've talked about Jones, or alluded to Jones reporting on this, suggesting that the Chief Justice changed his mind after the oral argument. There was Jan Crawford's reporting way back when in the Affordable Care Act case suggesting that the Chief Justice had changed his vote after oral argument. And I think the one thing that these two cases have in common is that there was concerted outside pressure on the court even after the oral argument. Here, in light of the documents that came to light from the dead political consultant's computer. In the Affordable Care Act case, it was this rather odd but seemingly sort of concerted effort through op-eds to really put pressure on the court. And I wonder if this is going to be a new fact of life in really big litigation before the court. You know, it used to be that after the oral argument, people just forgot about the case until it was actually decided. And now you're sort of seeing this post-argument litigation, whether actually in the courts or through the press. It's very striking and very unusual.
Virtual briefing, Allie Larson.
Yeah, looking over at Allie here. So.
You guys are now more important than we are.
This idea of the concerted pressure that an op-ed can impose on the Chief Justice of the United States, you really think that's a thing?
I think it might be a thing.
Good.
I thought you had a wall between your reporting and the op-eds, Adam.
I'm just delighted that the failing New York Times still has some influence.
Sad. But I actually think this is a slightly different case in a way than whatever was going on with the Affordable Care Act, because the reason that this stuff came out was not because people were litigating at the Supreme Court. It was because there was ongoing litigation in the district courts in related cases. And you can't expect people to stop their litigation in the related cases because the Supreme Court is deciding the census case. And so I think it may have had the same effect, but I don't think that it's right to say that what was really going on here was a kind of conspiracy in the civil rights community to take an issue that had been submitted for decision and to try to pressure the court out.
No, I think that's a little bit disingenuous.
No,
The
do that,
same
but-
day that they filed in the district court, they sent a letter to the Supreme Court. So I don't think they had their eye just on the district.
No, I mean, I'm not saying that they didn't try to also influence the court. It's just to understand that there was ongoing litigation about redistricting in which this material came out.
Yeah, and I would actually note that, I mean, apropos of what we were discussing earlier, you know, this sort of illustrates, I think, the same limitation on capacity that we were talking about with regard to the shadow docket, because in this case, because the proceedings were, you know, sort of, they weren't quite in an interlocutory posture, but they sort of were, you know, you had ongoing proceedings in the district court. You had this sort of new factual material being presented to the Supreme Court in this very unusual way, and the Supreme Court just does not have the capacity to sort of process that. And similarly, the district judge was like, what do I do with this information? Because the Supreme Court has the case. And so I think it just illustrates the fact that, you know, the Supreme Court, you know, operates at its best when it is operating in the traditional way. And I think it faces challenges just as soon as it sort of gets outside that context.
Well, I think it's also facing challenges now from the fact that we have an administration that is lawless in a way that was not true of prior administrations, whether Democratic or Republican. And so you have an administration that really, I honestly believe, wants to wreck the census and would be very happy to wreck the census and to have dramatic undercounts in minority communities. And the upshot of that is that, you know, Don Verrilli gave a really interesting lecture at Chautauqua earlier this summer about how does the Supreme Court respond to extraordinary cases. And he talked about the kind of current moment, and then he talked a little bit about what happened in Korematsu, which is, remember what Justice Jackson said there is, as a court, we need to just step out of this because anything we do here plays a role in later cases as well. And so one of the questions is, how does the court respond when you have an administration that has a very different attitude toward, at the top, I'm not talking about the whole administration, but at the top, has an attitude towards law that's just very different from anything that we've had in recent history.
I'm not sure everyone accepts that premise.
That this is a different administration?
On the court. There are some members of the court who are perfectly happy to say, we'll give deference to any administration, they get to set policy.
it'll be very interesting to see whether that's in fact true.
Okay. So you said earlier, Pam, that the court, in fact, was trying to lie low this term, and the reason it took the two big cases it took was because
It had to.
It had no choice.
Yeah.
And one of them because of a supposed deadline, which got softer once the administration lost. In the census case, they said they had to print the forms by June 30th, and then there was a little after-the-fact scramble. This next term, though, seems to be shaping up to be a much bigger term. We heard the case argued just now, enormously consequential cases. DACA, enormously consequential, very likely an abortion case. The court scheduled today for argument a case that may or may not be moot about the Second Amendment. Was that a holding pattern, you think, for a year, and now they're coming back? And do they care that all these decisions are going to come in June of 2020 in the midst of a presidential election?
Well, I mean, I had heard kind of through the grapevine that Justice Kavanaugh had said that last term they tried to avoid taking a couple of high-profile cases, and certainly, you know, the Title VII cases were teed up in the long conference last summer, and so they were ready for the court to decide did it want to take the cases or not in September, and they didn't take them till April.
It appears the fourth
Yeah.
vote was late in coming.
Yeah, yeah. So, you know, it took them a long time to decide whether they wanted to take that issue or not. You know, the problem is if you try to put off taking controversial cases, at some point you're gonna end up with a lot of them.
Do you guys think the presidential election figures in the court's thinking at all about when to hear
I mean,
cases?
they're human. I mean, I think it makes some, you know, look, the court still uses primarily the same criteria in every case. They're looking for square and acknowledged conflicts in the circuits. That's certainly true in the Title VII cases that they had to, you know, man, if you're ducking clear and acknowledged conflicts in the circuit and issues that arise on an almost daily basis, and then you've abdicated your responsibility as a court. So, you know, to some extent, you know, all things considered, would they prefer not to decide really hard and controversial cases? Probably up to a point. I mean, there must be some limit to how many patent and ERISA cases the court really wants to hear in a particular term. I don't understand that. I mean,
They've got COGSA if they need to fill the docket.
exactly.
That limit has not been noticeable in recent years, I mean, to be fair. I mean, I think there are relatively few cases of the ones you mentioned, with the possible exception of the Second Amendment case, Adam, where you could say the granting of review was really elective. I mean, I think most of these cases are cases that, I agree with Carter, that the court truly had to take. And when you have a case in that category, I think the fact that it's an election year or not really doesn't play into the calculus. After all, that's true 1 out of every 4 terms.
But, you know, if you come back with a question of, you know, should the court overrule X, and X happens to be one that you think might make a huge difference in terms of how the public perceives the court, you know, would you do that in an election? I don't know. I mean, I can imagine you might have a hard time picking up the fourth vote to go down that path in a particular circumstance. But as I say, that's because they're human. And, you know, look, they get paid the same either way, whether they decide hard cases or easy cases or whatever they do. So, you know, that's the beauty of the way this sets out. For the most part, except for the redistricting cases,
Well, and
they can pick their own docket.
Yeah, and their salary per case decided has gone up dramatically.
Another dynamic that might be operating here, of course, it only takes 4 to grant. And if 4 want a grant, they have to think about, is the 5th going to come along? And I could see, in the Louisiana abortion case will be an interesting example of this. What are they going to do with that case? Because to do something that looks like, I mean, they can't be insensitive to the effect it will have on the election if the headline is certainly court overrules Roe against Wade, or even court overrules Whole Woman's Health against Hellerstedt. They can't be insensitive to the effect that'll have on the election. So I think there's kind of maybe kind of a dance going on about whether, and again, I think it's the chief who's the key here, whether the other 4 want to kind of jam the chief and put him on the spot where, you know, is he going to vote against his team?
Are you sure that's the right analysis there? Because if they, having stayed the 11th Circuit, was it?
Yeah.
Having stayed the 11th Circuit, if they lift the stay,
The Fifth Circuit.
Fifth Circuit,
yeah.
Fifth Circuit, that answers the question. Don't they almost have to take it?
Yeah, I suppose since they stated, I mean, I suppose they could Yeah, I mean, what would they do now? If they lifted the stay, the Louisiana law would go into effect.
Effectively deciding the case.
Yeah.
So more broadly, where do you see the court's abortion jurisprudence going? I mean, this case it may well overrule Hellerstedt. It could distinguish Hellerstedt on factual grounds that the facts on the ground are different in the two states. So it's likely an application of Casey, not an assault on Roe. But where do you see the progress of the court's abortion jurisprudence going?
Well, I think that's really tough. If I were sort of in the middle of the court, I would be tempted in that case to say to the Fifth Circuit, look, this statute is the same as the Texas statute that we decided in Hellerstedt. Hellerstedt's 3 years old. Maybe Hellerstedt should be overruled, but we're the ones who are going to make that decision, not you, and summarily reverse. I'd be tempted to do that. And here's why I'd be tempted to do that. I think, however conservative the Supreme Court is, there are lower court judges who are going to be more conservative and who are going to think the Supreme Court is moving too slowly. And I think they're in a position to put the court in the same kind of position. Are you going to, we're going to do something that really amounts to overruling one of your decisions. Of course, we won't say that, but we'll do something that, finds some very fine distinction between something you've decided and in effect do something inconsistent with your previous decision. Okay, now what are you going to do? Are you really going to reaffirm this previous decision that we know you don't like? Or are you going to grant the case and overrule this case? And if I were on the court, I would say, I don't want you guys putting us in that position. If you're unhappy with something we did, here's the opinion you write. You say, oh, we don't like this precedent of the Supreme Court, but we're bound by it. So we're going to decide inconsistent with that. We hope the court will take another look at this case sometime. That's the way you do it. And I would try to teach the Fifth Circuit a lesson that don't put us in that box. But I don't know that they'll do that. But I can see a reason to do that.
I think the way that might happen is if the chief has really made up his mind already. And of course, it's hard to know what to read into that earlier stay ruling. But if the chief has basically decided, for whatever reason, that this is essentially, whole women's health 2.0, I could see him wanting to decide this case in as sort of summary a fashion as possible.
Yeah, I mean, we got a little bit of a hint of this from the opinions respecting the denial of certiorari in the Indiana sex selection abortion case last term, which is, remember, there were two pieces of the Indiana law that were up in front of the court. One was about the disposal of fetal remains, and the other was about a prohibition on abortions that were designed to select the sex or race, that were based on the sex, race, or disability of the fetus. On the first one, the court reversed and said, well, the rationality review is what applies here, and it's not an irrational statute. And on the second, the court said, well, we're denying certiorari here because we don't take cases, in parentheses, like this, unless there's a conflict in the circuits. And so I think what they're hoping is that the federal district courts and federal courts of appeals will continue to apply the precedents as written, and then they don't have to take the issue unless and until they're ready. By contrast, if what you have is things like the fetal heartbeat laws, if one of those gets upheld by one of the courts of appeals, there's no way to square that law with Roe against Wade. And there will be a conflict in the circuits, and there'll be the question of whether a federal court of appeals has kind of underruled the Supreme Court. And that's something that they may find it very difficult not to take. Whereas I assume that if the federal courts of appeals strike down the fetal heartbeat laws across the board, the Supreme Court's not going to grant certiorari on that.
So we have about 10 minutes left. I have a suspicion that there are questions from the audience.
Or you could just cold call on people.
Question.
Yes, Beth.
The discussions about the court deciding these injunction cases on such a short record and all of that, Haven't you seen though that even in the courts of appeals, it seems that injunction cases just across the board aren't treated as injunctions anymore. They're treated as merits. I mean, you can read Court of Appeals opinions where you think, oh, it's likelihood of success. It's said once and then it just disappears. So that to me seems to be, and I think now it's going to encourage it even more. So do you think that maybe is just part of it because we've moved away from injunctions really being litigated as something that is temporary before the merits? They do seem to merge in a lot of cases.
Well, that would suggest that it's actually the advocates who screwed this thing up, all right? I mean, so I'm pushing back against that suggestion, but no, I mean, there is something to that. I mean, and it goes to Cannon's point that we sort of press the litigation sooner because we know if it, to the extent it continues to drag out, we're never going to get to a final resolution of it. And if you can get the court to act on it more rapidly, although I have to say, I've mixed feelings about these things. I have a lot of cases where I think to myself, most people's knee-jerk reaction may not be positive to this. So maybe it's, let's just take our time and educate the court and hopefully get there in due course. But, obviously on hot-button issues, it's more important to get a decision quickly than it necessarily is to educate. And so, yeah, it probably is partly our responsibility.
I think there's some lower courts that have pretty good processes in place, and Beth, you'll have some familiarity with this from your time at the Justice Department. The Ninth Circuit has a separate track for preliminary injunction appeals that in my experience actually works pretty well, that moves them along pretty quickly, and that does have, yeah, but other courts don't. I agree. So it's, I think it's something that the lower courts
may have to adopt that.
Yeah.
Bob?
I want to go back, if we could, just a second to Roberts and the Commerce Department case. And some of us thought after that ruling that it wasn't over, that he had given the administration a way to do what it wanted. Some of us was called back from vacation because we thought the administration was about to do that. And then nothing happened. Did Roberts, in your opinion, know that he was killing this thing, or was he leaving the administration a way to get what it wanted?
Did John Roberts screw up Bob Barnes's vacation for no good reason?
The answer is no. The answer to your question, I think he expected that this was going to kill the question on the census. But the role you play, and candidly, you see this in a lot of DC Circuit opinions, is look, I'm not telling you can't get to where you want to get. I'm telling you, when you explain it this way, you're not getting there. Now, if you got a better explanation, bring it back, and I'll be happy to take a look at it. Just turned out they were going to run out of time. And even if the secretary had come back in and said, "Oh, my bad, I don't care. Did I say Voting Rights Act? No. I'm just curious about this information." That would have been a tough one to sell. Up through the court system again, quickly enough in order to allow it to go into place. So I think the chief genuinely meant, look, this is how a judicial review of administrative agency decision-making works. You come in with a bad explanation. If I reject it as arbitrary, capricious, or otherwise inappropriate, you get another shot at it. And if you run out of time, that's on you, not me.
Jesse?
No, that's good.
This is more of a journalism question than a legal one, but I
You can answer it.
can't speak for the editorial side, but I can. And I was struck by Ken's comment that this sort of op-ed campaign was odd. And I'm just wondering, I wanted to hear you say more about that. My initial reaction was, what do you expect us to do?
I think the thing that was unusual in the Affordable Care Act was that you had this sort of burst of activity that took place sometime after the oral argument. Usually, in my observation, what takes place is you have the oral argument, people write things for a day or two, and then the case sort of falls off the radar screen. And at least if you believe Jan Crawford's reporting, there's some suggestion that might have been because word was getting around that maybe the Chief Justice, in fact, had doubts. And, if so, that was concerning at the time, and I think remains concerning, both because it suggests that the court was in fact leaking, but also because it suggests that may have actually had an effect. And I do think that is pretty unusual, at least historically.
Yeah, I will tell you that if you asked me 5 years ago, and a client said, look, what value will it be to go and get a New York Times or a Wall Street Journal or any other editorial in support of the merits of the outcome of the case? I would say zero. Spend your money on your really good lawyer and don't waste the time. You may wonder why I come to that conclusion. But anyway, whereas today I might have a slightly different take on that question, which suggests that you can't. That's another button, at least in your arsenal, you got to think about.
But editorials have existed since, hundreds of years. There's nothing new about that. What is new is what Jeff and Ali have written about, the so-called virtual briefing, which is a little more sophisticated than most newspaper editorials, not Jesse's newspaper editorials, but other newspaper editorials. A justice once said to me, you guys write these editorials, do you think we've overlooked something? But the virtual briefing that Jeff and Ali write about take place, they kind of read like briefs. It's on the Volk conspiracy or Balkanization or some other blog, and it's by Marty Lederman, and it's, longer than, it would burst the page limits at the Supreme Court, these blog posts. That is new. Anything wrong with it?
Siri may have an opinion on that.
As a First Amendment man.
Interesting question.
Thank you, Siri.
Because too soon
Wait a
to
second,
tell
is she going to comment on our answers
Therapists will write
too?
in and say, why do you ask?
I think it's concerning because I would think it's concerning because, like Carter, I practice before the court in the traditional manner, which is to say through briefs and a developed factual record and through oral argument. But the reality of life in 2019 is that we all have information coming at us from every direction. I think that the research that Jeff and Ali and others have done, demonstrates something that I think all of us long suspected, but perhaps didn't know for certain, which is that judges and law clerks and others are reading all of that. And it is inevitably going to be influential if all of that is being read. And
frankly, it's just a really good argument for going back to 160 cases a term, because then they wouldn't have any time to read all that garbage.
well, particularly if we couple this with the justices being paid per case, this could be a great thing for the private Supreme Court bar. But I think it is concerning precisely because it is the Wild West, and if information is coming in and it hasn't been verified through the litigation process, particularly factual information, I do think that's somewhat concerning.
And that's been a problem with amicus briefs at the Supreme Court for generations. I mean, people come in with facts that are not tested by anybody, and where the parties don't even really get an opportunity to respond to them. And so it's not just the virtual briefing; it's the actual briefing by non-parties that causes some of this problem.
Yeah, so on the one hand, justices have always read a lot of stuff, and they've read law review articles and so on. But I think what's happening here is this is stuff coming out post-argument to which you don't get to reply.
Or, to take amicus briefs, sure, and Ali's written about this too. This is an advertisement for all of Ali's work. But the advantage with amicus briefs is if you're the oral advocate, at least you know what's in those amicus briefs and you know that there's a possibility that that's going to influence the court. Now you have no idea what the justices or judges on lower courts are reading and what information they might be getting. And something that I've started doing before oral arguments in the court is literally Googling my own cases and just seeing what is out there, just in case there's something out there that a law clerk or a justice might have read. And certainly that's something I wouldn't have done 5 years ago.
I think amicus briefs, of course, been around for a long time, but they really have exploded. And the Supreme Court litigation has increasingly taken on the sort of feel of a political campaign. You mobilize your side and you just flood them with amicus briefs, and you get op-eds and you get blog posts. And of course, at post-argument, it seems a little more troubling. I think pre-argument, when it makes positions there's an arms race to make your position look good, or make your position, that might have been sort of marginal, make it look legitimate. And you get person after person after person endorsing it. I'm not sure what to do about it. I think it's an artifact of polarization. It's an artifact of these very organized sort of legal teams. It's a Federal Society on one side and ACS on the other, and they're both trying to do this sort of thing, and various other interest groups are playing. And you have the feeling that, you know, the legal system works better when it's a kind of I mean, maybe this is old-fashioned or elitist or something, but a relatively confined universe of arguments that are acceptable, and kind of there's a good sense of what they are and what they aren't. And we've lost that. I don't know if there's any way back to it, but I don't think it's a good development.
Yes, one last question.
It's more a comment, but from an amicus perspective, the part of the case on special districts, and John Oliver had done a pitch on special districts. We responded to it in our amicus brief without referencing it, knowing that some court was going to look at this and laugh and say, special districts are the bane of America's existence. And it's real. So that's my, sorry for too many comments.
Okay, Eric.
Sort of relatedly to all this, is one bit of collateral damage going to be weakening of the institutional position of the Solicitor General as neutral, stable advocate for interests of the United States over the long term in an environment where, you know, the Solicitor General is more and more just some other advocate than.
Yeah, I mean, I gave you my take on that. I think the answer is no. I mean, obviously, there are going to be some instances where some people are going to react negatively to some positions taken. But if you look across the breadth of the Solicitor General's docket, I mean, the reality of the Justice Department, there are essentially three principles at work here. You have money, government wants it. Government has money, you can't have it. Otherwise, you go to prison. And those principles dictate the right outcome in about 95% of the cases, and the SG presents those principles as effectively as any institution in the United States, and accordingly will continue to receive respect for the positions that he or she takes in that regard. And the fact that there are a handful of cases in which they sort of spin in ways that get a lot more attention than what they do day to day will have some effects, but to me at least, much more limited.
So I think the Solicitor General's office is getting less deference from the court, but perhaps not for the reason that you were suggesting. I think it has very little to do with the positions that the SG is taking in, you know, the few high-profile cases, and more to do with the fact that the court has become, across administrations, more skeptical of, you know, the government's theories of criminal prosecution, of course, less deferential to the administrative state. And so I think just across the board, there's just a little bit more, and frankly, I think also less trusting of factual representations being made by the government, in light of the fact that there have been some pretty high-profile instances where those factual representations may not have proven to be completely accurate. And so I think really for a variety of reasons, I think you are seeing a slight decline, but I think that, again, that's administration over administration. That's not specific to any one administration.
I mean, back in the day when Carter and I were in the Solicitor General's office, I mean, if you had a criminal case before the Berger court, I mean, you had to work pretty hard to lose that case.
I was there for that, though. I could get that done. Yeah, exactly. That's what Fry gave me those.
I do think it's actually, I mean, people, Adam and others have talked about a sort of greater degree of agreement on the court. I think part of what has happened is the left and the right have converged. This is consistent with what Kannon just said, converged a bit on distrust of the government, where the liberals aren't as distrustful as they used to be. Used to have Justice Brennan and Justice Marshall, who were very hostile to the government position in criminal cases, and now the liberals less so. And conservatives are more distrustful of the government position in criminal cases. There's a libertarian strand there. I mean, not in every case, and maybe not enough, depending on your views. But I do think there is a kind of a distrust of government you know, not quite across the board, but much more so than there used to be on the court, and that's filtered into the reaction of the SG.
All right, we're over time. Please join me in thanking this fantastic panel.